Back on WPSD Local 6 Legal Line, Kevin Shannon of the Bryant Law Center in Paducah, our guest, answering your questions regarding personal injury at 1-888-208-6946. And we'll just do a swan dive right into the questions with Linda, who wants to know if a person gets hurt on someone else's property and needs to go to the hospital, who would need to cover the medical expenses?
Well, it depends. Typically, there will be some med pay coverage on residential insurance policies. It's usually pretty limited, maybe $1,000. Every once in a while, you'll find a homeowner's policy with higher limits, but not going to be real high. If it's a commercial property, there might be $5,000 or $10,000 in med expense coverage. Then again, there might be no med expense coverage. So if you're uncertain, you're going to have to talk to the property owner about it. And if there's no med pay coverage, then it needs to get turned into health insurance, Medicare, or Medicaid. And then if you're going to make any recovery, you're going to have to be able to show that the property owner was somehow negligent, which caused you to be injured on their property.
Sally wants to know about a triple bypass, which she had a few years ago, has now discovered that 2 of them didn't fit. The doctor who did the procedure has since left the country. Does she have any legal recourse?
That's a sticky question. The first thing you have to do is, I think, is answer the question, did the surgery not fit as you have described it on 2 of the procedures, because of something that the doctor did incorrectly. That's not something that you can answer. It's not something that a lawyer can answer. The mere fact that they didn't fit correctly would not necessarily indicate to me that the doctor did something wrong. So you're going to have your case investigated. There's going to have to be another surgeon that can look at it and tell you whether the doctor did anything wrong. If there's reasonable grounds to believe that the doctor did something wrong, you still could file suit. You would have to get the doctor served. That could be a very lengthy process of finding them and serving them. And then, of course, you got your whole lawsuit in front of you with no guarantee of how that's going to turn out. So that's a really sticky question you've got going on.
We have a question from Carl, who wants to know, if someone's tree falls onto someone else's property, would the owner of the land with the tree or the owner of the property where the tree fell be responsible for the damage the tree causes if it were to fall?
Typically, if a tree appears healthy and it just falls, then the person that has property damaged is going to bear the expense of the repair. If, on the other hand, the tree was clearly unhealthy, say it was dead and had not been removed, or it was leaning severely, maybe it had hanging branches that then came off and got onto your property and damaged your property, then the property owner with the bad tree would likely be responsible for that. So it all depends upon the health of the tree and whether it was obviously in some unhealthy state.
A little bit less than a minute to go, and we have time for one last question from Ivan, who was not wearing his seatbelt. Will that hurt his injury claim with insurance?
Well, it depends. If you have an obligation to exercise reasonable care for your own safety, that typically would include wearing a seatbelt. If the injury is to your head, neck, face, then obviously a seatbelt probably would have helped you, and the failure to wear the seatbelt is going to hurt your case. On the other hand, if you hurt your foot, broke your ankle, something like that, you know, it's doubtful a seatbelt really would have helped in that situation. So the not wearing the seatbelt might not hurt your case all that much, if at all.
Kevin Shannon of the Bryant Law Center has been our guest on today's edition of Local 6 Legal Line.